In June of 2026, the state of Florida prepared to execute Dusty Ray Spencer. At 74 years old, after 34 years on death row, Spencer was a frail man whose cognitive health was failing. Carrying out the sentence would make him the oldest person put to death in the state's history. This case traces back to late 1991, when Spencer's wife Karen asked him to move out of their home. During an argument over money, Spencer choked and threatened her life. Police arrested him, but he was released on bail, even though he continued to call Karen from his jail cell, promising to finish what he had started as soon as he got out. 2 weeks later, on January 4th, 1992, he returned. He pinned Karen to her bed and began beating her with a clothes iron. When her teenage son, Timothy, tried to stop the attack, Spencer struck him too, before ripping the phone cord from the wall and fleeing. Karen was hospitalized and required 11 stitches across her face. At the time, law enforcement operated in a specific legal environment, where domestic violence was often handled as a private marital dispute. To make a mandatory arrest, officers generally needed an independent witness to corroborate the assault. Without one, arrest warrants could sit untouched on desks for weeks. This witness requirement meant that despite Karen's injuries and the documented threats, the police simply took no preventative action. The system's protocols allowed a known violent threat to remain free, ensuring his behavior would continue to escalate. On the morning of January 18th, Timothy woke up to his mother's screams. He grabbed a .22 caliber rifle and ran into the backyard to find Spencer bludgeoning Karen against a concrete wall and stabbing her in the chest. Timothy pointed the rifle and pulled the trigger, but the gun jammed. Spencer turned a knife on the teenager, who was forced to flee to a neighbor's house. By the time police arrived, Karen was dead. The murder ignited immediate public outrage. Karen Spencer had contacted authorities, sought medical care, and provided physical proof of severe abuse. Yet the system had failed to prevent a murder that the perpetrator had broadcasted weeks in advance. In response, the Florida legislature rewrote the state's domestic violence protocols. They removed the requirement for an independent witness, instead mandating that officers make an arrest whenever evidence of abuse is present, regardless of whether the victim chooses to press charges. These changes also required police to provide victims with information on shelters and medical care, while strengthening the enforcement of restraining orders. The law shifted domestic violence from a private dispute into a severe state-level crime. Karen Spencer's death exposed a fatal flaw in how the state protected its citizens, leading to a system designed to intervene before the violence turns deadly. While the legislature moved to fix the protocols that failed Karen Spencer, the legal proceedings against her killer began to encounter their own procedural issues. In 1992, a jury convicted Dusty Ray Spencer of first-degree murder. However, the jury was divided on the punishment, recommending the death penalty by a narrow 7-5 vote. In 1994, the Florida Supreme Court reversed the death sentence. The justices found that the trial judge had improperly applied aggravating factors and, more significantly, had ignored documented evidence of Spencer's childhood abuse, PTSD, and chronic alcoholism. The case was sent back for resentencing in 1995. At this stage, the trial judge chose to act alone. He refused to impanel a new jury to weigh the evidence of Spencer's mental health and military service, instead reimposing the death penalty himself based on the existing record. By allowing a single judge to bypass a jury on a life or death decision, the court created a sentence that rested on a questionable constitutional foundation. The modern legal standard for these cases was later clarified in the ruling Hurst v. Florida. The court established that sentencing a man to death without a unanimous jury finding the necessary facts is a violation of the Sixth Amendment. Under the Hurst standard, the 1995 process that put Dusty Ray Spencer on death row would be considered invalid. Today, a judge cannot override the jury's role in finding the facts required for an execution. Spencer remains on death row due to his place on the timeline. Because his case became final years before these modern protections were established, the courts have ruled he is not entitled to the same relief as more recent defendants. The state of Florida is moving forward with an execution based on a judicial process that would be illegal to perform in a courtroom today. By June of 2026, Dusty Ray Spencer had spent 34 years in prison. He has aged, remained sober, and his physical health has deteriorated, but his scheduled execution date has finally arrived. Advocates for Spencer argue that executing a 74-year-old man who is cognitively declining after decades of incarceration is an act of retribution rather than a pursuit of justice. They contend that the sentence itself was built on a process the state has since admitted is flawed. Proponents, including the detectives who investigated the 1992 crime, maintain that the passage of time does not diminish the brutality of the murder. For them, the debt is still owed to the victim and her family, regardless of the defendant's age. This case presents two distinct failures. In 1992, the police were unable to intervene in a predictable tragedy. In 1995, the court failed to follow the jury requirements that now define the modern death penalty. The central tension of Spencer's execution is that the public is being asked to trust the finality of a decision produced by a system that failed to protect the victim at the start of the timeline and failed to follow its own jury requirements at the end. The Karen Spencer case successfully changed Florida's domestic violence laws, but as the state prepares to carry out the sentence, it raises the question of whether the justice system has evolved or if it is simply finding different ways to fail.